One case which illustrates how the European Convention on Human Rights might apply in the context of social work practice is McDonald against the United Kingdom. This had started off as a judicial review action challenging a decision taken by Ms McDonald's local authority about the provision of community care services. After she was unsuccessful in the courts in England, she took the case to the European Court of Human Rights. The background to this case is that Ms McDonald had mobility problems, partly caused by a stroke. As a result of this, there was a danger that if she got up to the toilet unaided during the night, she would fall and injure herself. Because of this, she was assessed by her local authority, which was Kensington and Chelsea London Borough Council, as needing overnight assistance, which involved somebody staying with her overnight who would be able to assist her to get to the toilet safely. Because of the reduction in funding available to the local authority, it decided in November 2008 that she should, instead of being provided with overnight assistance, be provided with incontinence pads. There was no proper reassessment of her need, leading to this conclusion, which could justify that change in provision. Eventually, in November 2009, her need was reassessed as being a need for provision of incontinence pads. Ms McDonald was very unhappy about this. She took the view that using incontinence pads was undignified and that it was inappropriate, as her problem was not one which related to continence, but to mobility. Overall, she thought that the local authority had acted illegally and, in addition, had acted in contravention of her rights under Article 8 of the European Convention on Human Rights. She pursued this claim through the courts in England, eventually ending up in the Supreme Court, but was unsuccessful. She therefore took her case to the European Court of Human Rights. One of the first things to note about the decision of the European Court of Human Rights is that, in contrast to the courts in England, it took the view that in this situation, Ms McDonald's Article 8 rights were engaged. In particular, as illustrated in the quotation on the slide, it took the view that someone's Article 8 rights could be engaged where they were forced to live in a way that conflicted with their strongly held ideas of self and personal identity. The court clearly took the view that Ms McDonald had a very clear idea about herself and her identity, and a very clear belief that it was undignified to expect her to use incontinence pads. However, the engagement of Article 8 is not the end of the issue, and the engagement of rights does not necessarily mean that they have been infringed. This is because Article 8 is a qualified right, which means that individuals' rights under Article 8 can be overridden by other considerations. In order to succeed in a claim based on Article 8, you need to be able to establish that the action of the government or other state organisation, such as a local authority, was not in accordance with law, did not pursue a legitimate aim, and was not necessary in a democratic society. First of all, in accordance with law. For our purposes, it is enough to note that this requires that decisions are taken in accordance with the domestic law of the state against which the claim is made. In respect of this, the European Court of Human Rights distinguished between the first decision in November 2008 and the later decision in 2009. It took the view that the first decision to change provision was not in accordance with law because no reassessment had been carried out before the decision to change the service was made, as required by community care law in the United Kingdom. Because the decision was not in accordance with law, the European Court of Human Rights decided that Ms McDonald's Article 8 rights had been infringed as a result of this decision. However, the court decided that provision after November 2009 was in accordance with law as it had been preceded by a reassessment, though it can be argued that the judges took a very generous view in deciding that the local authority's actions amounted to a reassessment. The 2009 decision was also considered to pursue a legitimate aim, namely the economic well-being of the state and the interests of other care users. The interests of other care users were relevant because spending more on Ms McDonald meant that there was less available for other service users. Finally, it had to be determined whether interfering with her rights was necessary in a democratic society and whether the action was a proportionate way of achieving the local authority's aim. In this context, the court gives member states a wide range or margin of appreciation In other words, it recognises that states have to have some range of discretion when it comes to taking decisions, particularly decisions of the sort involved here, which involved allocation of scarce resources. In this case, it took the view that the decision taken by the local authority is proportionate, because at every stage in the court proceedings in England, the interests of the public and, for example, other service users competing for scarce funds, and those of Ms McDonald had been carefully balanced. In relation to the November 2009 decision, therefore, Ms McDonald was unsuccessful, and this illustrates the difficulties that arise in effectively using Article 8 in community care cases where there are always going to be these sorts of decisions about resource allocation, balancing the interests of one service user against those of other service users and against the broader public interest. The other interesting issue which arose in this case, and has arisen in other cases in the past, is whether or not the state and local authorities have a positive duty to act where they become aware that someone's Article 8 rights are being infringed, and, if there is such a positive duty, what the scope of that duty is. The court did not consider this issue in the McDonald case, as it considered that the claim was not one of lack of action by the state, but whether the actions it took infringed Ms McDonald's Article 8 rights. It did, however, confirm earlier decisions that such a positive duty does exist in principle, but none of these decisions, and that includes now McDonald, have made clear the circumstances in which it would arise.